study this subject in Afghanistan?
The interpretation we study as part of a subject. As a part of a subject.
Support?
Yeah.
Which subject?
Comparative constitutional law.
Okay, so it was part of comparative constitutional law that you studied.
2 lectures.
2 lectures only.
Yeah, and I have a question, sir, from you.
Yeah, please.
As we studied here, so our system is completely different from this system.
Why don't you use microphone so that it is. Yeah. Yes.
Sir, as you know, our system is completely different from your system because we are following the civil law system, or we call it Roman Germanic system, and here you are following the common law system. So legally, the interpretation is also different in Afghanistan. Usually, we have in all over the world 3 kinds of interpretations. I mean the institutions for the interpretation of the domestic laws. One is the judicial, one is the parliamentary, and the other is the political interpretation. For example, in France, if you see, there is the concept for the interpretation of the constitution. For example, if you see Indonesia, there is a constitutional court for the interpretation of the constitution. In some countries, the parliament have, I don't know the exact example of that. But in our country, that according to our 121 of article of our constitution, the interpretation of the other laws is with the Supreme Court. But the interpretation of the constitution is with the Constitutional Commission. So I don't know that which kind of, so in different domestic laws, which interpretation will be the best interpretation for the constitution, and which is the exact, can give us the exact, for example, meaning or exact interpretation in the domestic law according to your views.
Yes, thank you very much for your comments. You see, if you see domestic legal systems, which are primarily divided into 2 kinds. Systems which originated directly out of the English common law, or systems which adopted and adapted, you see, to the English common law, and then with their own developments, particular developments, such as the United States of America. And then there are altogether different legal system, that is civil law system, mainly of civil law system of Italy originally. Then later on, France became a better example of the Romanistic legal system, Romanistic legal family. Then of another variant of, so you have France and Italy on the one hand, one example of Romanistic in the civil law. And then you have Germanic legal system of the civil law. So civil law systems are divided into 2 families. One is a Romanistic family, and in the Romanistic family, best examples are 2. One is France and another is Italy. Then you see another division that obtains in the civil law family, that is of a Germanic legal system. Now in the Germanic legal system, you have the best example, of course, is Germany. Then you have another example of Austria. Then there are several other examples which are mixed examples, which may not be able to be categorized in one. For instance, Romanian legal system, Egypt legal system. You see, or for instance, another very good example being the Swiss legal system. You know the quality of Swiss legal system. The best quality of Swiss legal system being the coexistence of all the legal systems. I mean, like civil law, common law. Predominantly it is civil law, and within civil law it is leaning more towards Germanic legal system. And it is no coincidence that German-speaking people are the most, common in Switzerland. Now, one distinction, there are some fundamental, let us try and make some, in order to be able to give answer to what you have said. One fundamental difference between the common law legal system and the civil law legal system is the existence of codes, written law, prayitas, for instance, in other words, jurist, in the case of civil law system, and on the other hand, in the common law system, the absence of codes historically and in terms of the genesis of this legal system. So, common law system originated out of the judgments of the courts. So, in the civil law system, as far as laws and legal systems are concerned, the most important class of people is judges. In the civil law system, the most important class is the jurist. Jurist is basically a person who is actually the lawgiver. And magistrate and judges are those who apply the law to particular set of facts. So they are considered intellectually inferior to jurists. Of course, the concept of jurist, at least academically, is not alien to the common law system. But as far as functionally is concerned, I am not aware whether there is any functional role which the common law has ascribed to jurists. They are judges. That is one fundamental distinction. Now, but of course, when we talk of this, we talk of history. And as we know, as civilization grew and legal systems interacted, there are always give and take. Now, there is hardly any typical common law country today. Even in England, after 1832, you find several statutes. Today, you also find a Supreme Court, which did not exist before 2009. So there are give and takes. We also have, statutes. England also has statutes. And even common law system. So, this statutory evolution of a common law is certainly the willingness of common law, or maybe the compulsion of common law to learn from civil law. And in the civil law system, you find that there are several things which the civil law system has taken from common. For instance, equitable remedies. This is typically of common. Now, if you come to the constitution, when you talk of constitution, you may not necessarily be imagining the situation of the absence of a written constitution. Constitution does not necessarily mean the presence of a written constitution, but mostly it is the case. When you talk of constitution, it is mostly correct to say that there does exist a written constitution. Now, when there exists a written constitution, unless, of course, there is a convention like in the United Kingdom, historically speaking, which is based on conventions, rather than on any written, form or on the basis of judicial interpretation. In all other forms, all other ways, in all other countries, wherever there exists a constitution, there also exists in the constitution some machinery, some mechanism to give authoritative interpretation of the constitution. And again, in almost all cases, it is the judiciary itself. So where there is a constitution, there is a body to say what the constitution is. And there is this body called, judiciary. Unless, of course, there is a provision in the constitution that a political body, for instance, like in the system of Hong Kong, because for a very long time, Hong Kong had a typical legal system and it was part of this United Kingdom, and once it ceased to be a part of United Kingdom, then you have more leanings towards civil law. So you have in the system of Hong Kong some interpretation given by political organs, other interpretations given by the judicial body. But like the Constitution of the United States, Constitution of Canada, Constitution of India, for instance, you have a body within the Constitution. And the Constitution has authorized the judiciary, the court, the Supreme Court, to say what the Constitution is. Because powers of each organ of the government is delimited by the Constitution itself. So there is a government by Constitution. That is called constitutionalism. So the existence of a constitution is a necessary condition for the operation of constitutionalism, but is not a sufficient condition. Sufficient condition is met only when the government, that means all organs of the government, legislature, executive and judiciary, function according to the provision of the Constitution. For instance, the case of Pakistan. There does exist a constitution in Pakistan, but constitutionalism has often failed in Pakistan. In other words, if there is a coup in a country where there is a constitution, it is a failure of constitution. Which means that the constitution, you see, failed to delimit the respective, you see, areas of jurisdiction and powers. How do constitution usually evolve in terms of interpretation? Lawmaking is the domain of the legislature. Legislature exercises lawmaking power. And this lawmaking power may well be in the form of a constitutional interpretation. If you see Indian Constitution, you have several amendments to the law which are essentially in the nature of interpretation. Land reforms legislation, several amendments, and in several amendments there are several provisions. But, mind you, that is one thing. But second thing is, whenever the parliament exercises this power of lawmaking, whether that lawmaking, whether it be in the form of an insertion of a provision, deletion of a provision, or giving an interpretation of the provision, is ultimately subject to judicial review. If the court says that this insertion is ultra vires the Constitution because this offends the basic feature of the Constitution, then this won't survive. Whether the Supreme Court says that this is beyond the power, amending power of the legislature, it won't survive. So ultimately, what the powers of the legislature are is ultimately to be determined by the Supreme Court. In the United States, the best case comes from the Marbury versus Madison case, which established the doctrine of judicial review in the Constitution of the United States. There are several, you see, when we have discussed a couple of cases, remember there was a case, I do not know whether you attended that class. Did you attend that lecture 7 or 8 when we had 6, most probably lecture 6 on purposive interpretation? Did you attend that lecture? Because there we discussed this. We had this example of Canadian investigating authorities investigating in a manner in which these authorities violated the provisions of the Constitution. Then the Supreme Court said that Constitution is a living document and which is evolved over time. But let me tell you very quickly the conclusion on this point. Constitutional interpretations are not intended to be static. They are evolutionary, and on this point I think there is an almost unanimity in the literature on law of interpretation. Judges and academic they have adopted different terminology. For instance, there is a terminology called living tree interpretation. Living tree. Living tree means there is a tree. When you plant a tree, a sapling, you are not aware of the shape that it is going to take after 10 years. But it is the same tree. That is what is the idea is basically communicated. So, in other words, if we transpose this language in the legal language, means by way of a constitution sapling. So, you have planted in your country. If your country is the earth, constitution is your sapling. So, you have planted this sapling and you have to preserve this. So, wherever it is going to take its branches to, you have to respect that. So all other trees, for example, all other laws will have to respect this tree because this is the tree of the constitution. So this is what they say. Living tree, evolutionary interpretation. And you have several examples. Because this is not addressed, this is not a particular law on Motor Vehicles Act or for instance Prevention of Corruption Act or Consumer Protection Act. This is the supreme law of the country. So on which everyone agrees on this point. And similarly, you see, if one more general observation, if I may make, is statutes or treaties concerning human rights. If any other branch is given evolutionary, purposive, liberal interpretation, then that is the branch of human rights, both domestically and internationally. And on this also we have discussed at least one very well known case internationally speaking, that is Atala Rifo case, that of Chile, that went to American Court of Human Rights. That is a path-breaking judgment given by the American Court of Human Rights, which I think we discussed in that lecture 6, purposive interpretation. So when you see your mails, you will find these readings. Atala Rifo, judgment of Inter-American Court of Human Rights of 2013, 2012 or 13. Then there was another judgment on constitutional interpretation, Canadian Supreme Court, that you will find in the readings. So this is about constitutional interpretation and you see civil law and common law differences. But today you see there are not much differences which exist because of the developments of law and interaction of different legal systems. Would you like me to say something more on any point that you raised? It's sufficient. Thank you. So we start with this. The last substantive topic. Because in the next class we will not introduce anything new. We would summarize the discussion that we had in the 12 lectures. So we come to equity and other considerations in interpretation. In terms of other considerations, you find that often in a legal system there do exist so many treaties and statutes, and sometimes it is apparent or it is claimed by one or the other party that the treaty or the statute that one party relies before the court and is opposed to by the other party. They say that these legislations are basically contradictory. Now, in the oldest system of interpretation, that is Mimamsa principle, there is a doctrine which, of course, our students do not know through Mimamsa system. They know it through English legal system, that is called harmonious interpretation. But when you see Mimamsa principle, this existed, several thousand years before English legal system. Law did not exist in England before 1066. You will be surprised to see. In 1066, Normans invaded England. 1066. It means whatever you talk of United Kingdom is less than 1000 years old. Less than 1000. So we are not still 2066. And that I am telling you, when Normans invaded England, law did not exist. The earliest recorded, you see, documents of English common law, you see, I think 1215, that is Magna Carta, and before I don't think we are aware of anything that exists. 1215. That's it. It is exactly 799 years old. And this system is of more than 3,000, 4,000 years, 3,000 years. And this, there was an axiom, whatever you would like to call it, that is called Samanjasya. Samanjasya, either it is conciliation, whether you call it conciliation, reconciliation, harmonious or whatever, which means consideration of the other, assimilation of the other.
Is it similar to the ADR?
No. You see, ADR, ADR is itself is not one particular method. It is a branch of law which is distinguished from the adversarial system. Yeah. That is alternative dispute resolution. So one way you go to court, that is essentially formalistic and adversarial, and other being mediation, conciliation, you see, good offices, and even arbitration. In other words, where the role of the third party is limited and the role of a parties is given more prominence. And as we move from, arbitration towards mediation, so the role of parties gets more and more importance. It is not about that. What it says is this, and it is clearly stated, all attempts should be made at reconciling apparently conflicting texts. If two texts appear to be conflicting, so what you should do is, the maxim says, the principle says, that you should respect both. And you should interpret one in such a way that the effect should be given to the other also. In other words, you can't interpret one statute in such a manner as to efface from record the existence of the other statute. You must give effect to both. That is what it says. In other words, if you have to take 2 classes and you only have 1 hour, so this means that you attend half hour's class, so that you can attend both the classes. That is what it says. But if you insist, no, we have lectures only of 1 hour, how can we attend, half-hour lecture? So that means that you are basically doing in such a manner, interpreting class in such a manner. In other words, if it says that you have to attend 1 class, and the time available to you is only 1 hour, so how do you interpret class? If you interpret class hour as 1 hour, the result will be, you will attend only 1 class, 1 teacher's class. The result will be the other teacher, you will not attend the other teacher's class at all. But if you interpret class in such a manner, this is fine. If you have to take 2 lectures, we have only 1 hour left. So the best thing is to attend half-hour class. That is what it says. So you have to reconcile. So if there is in a text expression class, and one statute says class is of 1 hour, other statute being silent, I am giving you a most simple example. Then how will you interpret class? If you interpret class of 1 hour, in a given case you have to attend 2 classes, and time is available for 1 class. So if you insist 1 hour, which means that other statute is to be totally disregarded. If I should give you a real example, Indian students would recall right to preach, practice and profess religion under Article 25. And then you have in the next article the right of religious denomination to establish and administer the religious institutions of their choice. So this is one area in which very historically, very famous case. Venkateshwara Devaru versus State of Mysore. The Supreme Court applied the doctrine of harmonious Samanjasya axiom. They interpreted both these provisions in such a manner that it was possible to exercise both these rights. And people who are preaching, professing and practicing religion must also be given the right to establish. Contrarily, people who want to establish and administering a religious institution must also be given an opportunity to be able to exercise right available in Article 25. That is how the Supreme Court interpreted. So here this is this principle, very famous principle of harmonious interpretation. Then there is another principle which is very famous principle in Mimamsa principle, and people who speak Hindi may well understand the meaning of Vikalpa. Vikalpa essentially means an alternative. Yes, alternative. You are absolutely right. Vikalpa means alternate, option. Another option. Now what does it mean here? What it says that if there is a real and irreconcilable contradiction, real is opposed to apparent. Look at it. In the earlier slide, you saw the word apparent. Now there is the conflict is real, which means it is not apparent, it is a real conflict. And then it is further clarified, the conflict is irreconcilable. In other words, this is not possible to interpret two statutes in a conciliatory manner. You can give effect to one, but you can't give effect to both. So the question is, you have to make a choice. What do you do? Then what it says is this. Between the two legal rules having equal force, the rule more in accordance with equity and usage should be adopted. Now, what does it say? It says is this. If on the basis of the text, letter, the conflict is inevitable, you can either choose A or you can choose B. You can't do both. Then this adage, Vikalpa adage says, then which of the two should be chosen? Guidance says, the one which is more equitable and usage, that means the practice and usage, that should be chosen. Again, if I should, you see, that hypothetical and a very simple example of a class. You have 1 hour, you have to take 2 classes. It is not possible to reconcile. Then you find out, if this is a problem in the law school, what should you do? You should go to the School of Social Sciences. Did it happen in your department? They said, well, this happened. So what did you do? We only attended this class. Okay. Then you go to computer science department. Find out the practice. If there is some guidance from other departments, so you also adopt that. That is one way. Second is, what is more equitable? Equitable means, example, suppose you have 2 classes. One class is of law of the sea, another class is international organization. And you have to attend which of the classes. Now you find out on which subject did you have more classes. If on law of organizations you had already 20 classes, and law of the sea you only had 15 classes, then you attend law of the sea class, so that you should bridge the gap between the 2 subjects. You will have 16 and 20. If you attend law of this organization, the difference will be 21 after attending this class. This is how you do it, because you have to study both the subjects. So I think these are very simple examples. So you adopt the practice or you adopt this equity. That is what it says. This is called vikalp. So vikalp means it is not any arbitrary option. No. When you say vikalp, vikalp means an option which is a sound option. It is, for instance, you can't say that we don't attend any class if there is a problem. This is not a sound option. I mean, there may be, of course, there are all kinds of students. Some students who don't want to study, they will also give you this option. Yeah, why are you fighting? You should not attend any class. Let us go to canteen. So canteen can be an option. Canteen can't be an option.
So you can say better. You can say like it's a better option. You have to choose the better option.
You see, the option, the question is, the option must have the support of these.
Equity.
Either it should be, equity or usage. Let me put it like this. Is it the usage that you go to canteen? If you say yes, then you say it. We went to social science department, they say it. Under these circumstances, this is the practice of this department to go to canteen. Fine. Or you say, this is the equity, that we should go to canteen. So what we are saying is this, it can't be in order that an option should not be arbitrary or ridiculous, absurd, unreasonable. These, if you apply these, then option can't be arbitrary. An option must be option which is equitable or based on usage, that is practice. That is what the Mimamsa principle would say. Of course, this is history, and this is certainly not a modern legal system which is supporting. Let us come to the modern concept of equity. What is understood by equity under both common law and civil law. The first observation is that the word equity has originated from the Latin, that is Latin of course is the language of civil law. Latin word equus. When you translate equus into English, you have no one word translation. There is no single word in the language of English which is capable of capturing the whole essence of the Latin word equus. That is first problem. So therefore, you have to choose more than one word. And these two words are fair or just. Now when you see it in terms of concepts of modern legal systems, then you see what is the result. Fair, when you talk of fairness, you talk of substantive fairness or procedural fairness. Example, Article 14 of the Indian Constitution. Because it talks about both. Substantive fairness, that means the law must be a fair law. And then, even the fair law is not enough unless it is administered fairly. It is like this. You make an advertisement. South Asian University invites applications for the position of professor, associate professor, assistant professors. All are welcome to apply. What is this provision? This is a provision which is substantively fair. Means it gives right to everybody to apply. It is a substantive fairness provision. But now you see procedural fairness. When you give applications, then for instance, Deputy Registrar receives applications from people sitting on this side, and people from this side they say, well, I won't accept your applications. And you say, why? Well, I will not accept it, that's it. You come tomorrow or you come next week. And before next week, the date of submission expires, so ultimately you are not able to submit your application. This is called, what is that is, substantive fair law resulting in procedural unfairness. You did not allow these people to exercise their rights. So do you see the importance of fairness? So for these people, what is the meaning of substantive fairness? If you did not want to, you see, accept their applications, this was as good as they did not have a right. So procedural fairness is also important. Substantive fairness is not enough. For instance, a law gives you a right, but gives you no remedy. You can't approach the court. For instance, most of the people in this country, many people are languishing in jails. Many, several lakhs. Simply because they can't afford a lawyer. Or a lawyer, and worth its name, his name or her name, who is going to be heard by the court. There is a strong professional bias in terms of practice and attitude of courts. I am very sorry to use this strong language, but I have a very quick example so that you should not feel that you are misled. An LLM, an MPhil, and a PhD scholar of JNU was refused to be heard by a judge of Delhi High Court, saying that I will not hear you. You hire a lawyer. Who is a lawyer? An LLB. And then this student, because it came to my knowledge, I said, you approach the Supreme Court. He approached the Supreme Court. Of course, he was harassed because he had to undergo this harassment of the Supreme Court, but then he had a brilliant judgment in his favor. Supreme Court passed strictures on that High Court judge, saying that you would be better understood when you have a support of an LLB qualified person than a person who is LLB, LLM, MPhil and doing PhD. And he is arguing his own case. Simply because he is not wearing a black coat, it doesn't mean that he is legally unqualified person. Bhagat Singh, Sardar Bhagat Singh, have you heard of?
Yes, sir.
I do not know how many people are aware of his understanding of law and the English language. Amazing. Amazing. His handwriting was published 4 years before in the Hindu newspaper, which he wrote in 1915 or 1914. So you can immediately gauge the language, the legal understanding, and the English language. So what we are saying, that is what I said. This procedural unfairness. Because they don't hear you. They said you come through a lawyer. I understand if a person is a rickshaw, you can't hear him. But in my opinion, if I should be a judge, I will hear a rickshaw. And there have been judges in this country. There have been judges in this country. Justice Chinnappa Reddy, Justice very famous judge who is now with Competition Commission, S.N. Dhingra, one of the most respectable judges of Delhi High Court. He would hear a rickshaw in person. Whatever language you want to hear, you say it. I will translate for you. He would say, then I am your advocate, don't worry, say it. So this is called procedural fairness. And procedural fairness is very important. Because whatever rights the parliament gives you, they are going to remain on paper. And this precisely what happens. You are not able, you say Supreme Court, when you say, how many people can approach Supreme Court? Just tell me.
They all are exhausted in high courts.
Yes, that's what we are saying. You just can't go to Supreme Court. By the time you reach High Court, 75% of the litigant has lost its total energy before you reach High Court. This is at the time of reaching High Court. And then you litigate before High Court. By the time you get a judgment from High Court that is not in favor of you, you hardly have any interest, any money, any energy to do it. Let me tell you, you see, something very, very simple and straightforward. If you have a claim of 5 lakhs rupees, I would never advise you to go to court. It is foolish to seek a judicial remedy for a 5 lakh rupees claim. Because there are more than 50% chances that you will lose more than 5 lakhs in litigation. And even if you are going to lose 3 lakhs and you are going to get 2 lakhs, you know when will you get it? After 5-6 years.
By the time it would be.
By the time the value of 2 lakhs would be 20,000 rupees. And number of holidays, number of work that you have missed, number of opportunity that you have missed are more than 20,000 rupees. That is the procedural fairness. Students of law, professors of law, teachers basically, they underestimate procedural fairness because of their profession, because they have never witnessed courts, neither as litigant nor as professionals. So they have absolutely no idea. They believe that substantive fairness is good enough. If somewhere it is written equality before the law and you also have this right to do this, you have a right to do this, and that's good enough. They do not believe that this is absolutely nonsense. You just go and fight. You see, take the example very simple. Recently we had, Miss Jayalalitha. She could afford a Ram Jethmalani before Karnataka High Court. And when he was not successful, next day she could afford Fali Nariman. You know, who are these people? I think even people from outside of this country, by now they are aware of these people. They are the tallest celebrity heroes of Indian bar. Most of the Supreme Court judges professionally are 25, 20, 30 years junior to them. They started their career at the time when they were already celebrity. If you see the biodata of Chief Justice of India and see this biodata of Fali Nariman and Ram Jethmalani, you will find that when they had become, you see, celebrity, then they started their legal career.
Fali Nariman's son is in Supreme Court judge.
You can imagine that. What can be a better substantive thing and a more his awe on the fellow judges when his son is a sitting judge? Now, do you think that she is the only person in India whose right would be infractuous if she is not given bail when her appeal is pending before High Court? There are thousands in this country, and their only misfortune is not that they did not have substantive right to appeal. They have procedural backing. They can't simply use the procedure. It is like this. We say that there are 100 flights to Bombay available. You have a tomorrow interview. All of you have an interview tomorrow. And you will surely get a job in Bombay. If anyone in this class doesn't have money to buy a ticket, would mean a job available to you is gone. That's it. You are in Delhi, 100 flights, everything. But question is that enough? That is precisely the case. So Jayalalitha also had the same substantive right as anybody in this country. But that is only half of the story. And when you see it is not backed by the procedural fairness, then you see that that substantive fairness is absolutely afforded. It's very simple. Unless you should be able to afford a Fali Nariman or you see Ram Jethmalani or Kapil Sibal or Abhishek Manu Singhvi or Mukul Rohtagi or Harish Salve, these 10 lawyers, 10 top 10, 15 lawyers. Forget. And hiring these people, you know, I can't tell you the amount. Ram Jethmalani admitted that he charges 3 crores. And none of them, all these people I have named, nobody would charge less than 50 lakhs if a case matter is before Supreme Court. absolutely foolish. So that is, so when we talk, let us get back to the point. When we talk of equity, one way we talk of fairness. But please remember, fairness is not a unitary concept. Fairness is a twin concept. It's a dual concept. It implies both substantive and procedural fairness. As a student, you are taught much too often about substantive fairness, but believe me, whatever little experience that I have, of course, I would say procedural fairness I have found to be far more important. That will open your eyes. Then you will really understand the law. And really understand the law mostly differently what you have as a student. Then, another alternative concept of equity is what is just. Remember, when we discussed, we remember our third lecture. You have readings in your mails and you can find from the slides. I think that was the most exhaustive lecture you see that was delivered here because the number of slides were more than 28 or 29, 90, 29. And in that class, we discussed these theories of justice. The point is very simple. It is too simple and too often to talk about justice. But justice is a thing which has always been debated. But justice is also a thing which has yet to be conclusively debated. Since the time of Plato, every society has debated justice. We do debate justice. Every day when we see in newspaper some judgment or the other, we debate justice. Even yesterday when the Supreme Court said, Mr. Sinha, you must recuse yourself. Again we talk of justice. Is it just for him to remain? Is it just for the government to allow him to remain even if he has to be there in office for 12 days? So what I am going to tell you is this. It is never conclusive. And the reason being, there are so many theories of justice. Look at it. I just recall, because we don't have time to tell you, elaborate on this, we have already done it. We have a concept of dharma. It's a positive notion of dharma, of justice, that comes from this structure. Then you have a distributive theory of justice. You have entitlement theory. You have a rights theory. You have a formal theory of justice. You have a feminist theory. You have economic theory. You have corrective theory. Then you have the English law concept of justice, equity and good conscience. Then you have a statutory form of justice. These are things. So in other words, when you talk of just as an alternative concept within the concept of equity, then you have to choose or you have to reckon with any one or more of these theories of justice. So that is something again, you see, very important in the concept of equity. But let us go back and see how the concept of justice concept of equity has influenced statutory interpretation. There was a very simple case before the Supreme Court of India in 1985. This was Bhagirath and others versus Delhi administration. This concerned criminal law, and the sole question before the Supreme Court was what is written in the first sentence. Whether imprisonment for life is imprisonment for a term. That was the question. This question was important in the context of the legal provision. That is section 428 of the CRPC, which in the relevant part read as stated that where a convicted person has been sentenced to imprisonment for a term, any period of detention undergone by him during the investigation, inquiry or trial of the case and before the date of conviction shall be set off against the term of imprisonment. This is what section 428 of the Criminal Procedure Code said. Very briefly, you see, as soon as you are convicted, then only the period of sentence would start. But what about that period which you have already spent when you have, let us see the case of Baba Rampal. Just take the very latest case so that you can better understand. Rampal yesterday was produced a day before as scheduled before the Punjab and Haryana High Court. He was given sent to judicial custody until 29th of November when the case is listed for hearing again. Suppose the case in which he is charged, he is already on bail, the bail was cancelled. In any case, he was there in jail earlier. I don't know for how many months or how many days. Maybe. Let us start afresh. He is going to be in jail, let us see, for 1 year or 2 years. One day, the trial on the sections he is charged with is going to be completed one day or the other, and then he will be sentenced. The time that he has already spent before he was convicted, what about that time?
So somebody is accountable in our country just when he convicted in the jail, the police custody. After getting bail, it's not accountable. But when he's in the police custody...
No, of course, when you are on bail, you are not in custody.
Yes.
So obviously we are not talking about bail. Bail means no deprivation of personal liberty. We are talking of personal liberty. We are talking of when you are imprisoned.
But it is accountable.
So, is
This period is countable.
detention or
Detention.
Detention.
Yeah.
It is countable.
So, this is the whole question. Now, it was argued before the court that if a person has been sentenced to life, then that person has not been sentenced to a term, because life is not a term. Do you see the logic? You said it, in your country it is counted. That is the same thing in our country. But the whole question is this: if you have been sentenced for life, it was argued before the court, then since life is not a certain term, so how can you count it? There the Supreme Court introduced the concept of equity. Supreme Court said the fact that life is not fixed in every case does not mean that it is not a term. And where does it say, where does the provision say the term must be a fixed term? A term of imprisonment for life, the term is life. See, you could be imprisoned for 2 years. The term is 2 years. You could be imprisoned for 3 years. The term is 3 years. You could be imprisoned for 7 years. The term is 7 years. If you are imprisoned for life, the term is life. That's it. And the fact that your life is, my life is different, it doesn't mean, in other words, in your life, that is the term. In your case. And in my case, it is my term. So where is the contradiction? Does it say it is a quantifiable, mathematically precise number of days, hours, minutes, seconds? It doesn't say it.
but still there is a problem because for the same matter, all of our lives are not fixed or like some people live 50 years, some 60 years, some 70 or even some 100. Okay. But if a person lives 100 years, he will suffer more than if a person lives 50 years.
Yes, that is true. That
And
is true.
another question is that in our country is when is the life imprisonment, it will be countable as 30 years.
No, I'm coming to that, and that's a part answer he has already given. See, the point when you say it is imprisonment for life, it is actually not imprisonment for life. It is imprisonment for a period. And of course, there are provisions, you have to make an application. In our country, generally it is understood at 14 years. 14 years. So 14 years period is, you can say, a judicial fiction, a fictional life. fictional life is 14 years. They go with it. But when you see the provision, it doesn't say anything about this. Now it was argued before the court that this fellow has been, you see, imprisonment for life, so you can't remit, you can't discount that period which he has undergone. Supreme Court said it, this is totally unreasonable, this is totally iniquitous. That is what the court made this observation. The fact that the term of life of an uncertain duration does not justify the conclusion that the sentence for imprisonment for life is not a period or for a term. It is for a term. And life itself is a term. And then the Supreme Court made, you see, a principled observation. That is what where you see you can find the precedent. And that is it. Equitable considerations must have an important place in the construction of beneficent provisions. So, section 428 of CRPC is a beneficent provision. Parliament has enacted this provision for the benefit of a convicted person, and therefore, if there are two interpretations, if there is a possibility of more than one interpretation of a particular term, the interpretation which is favorable to the convicted person, for which the provision was enacted, should be adopted. And now the reason for conferring this benefit by way of interpretation was equity. So equity was the device that was used by the court for conferring the benefit to the accused person. That is what the court did. Now, is there any question of this point? It's clear. Okay. Now you see, we start with another case, that is a case concerning international law. That was domestic law, and within domestic law that was criminal law. We take an example from international law. Have you heard of this case, frontier dispute, Burkina Faso and Republic of Mali? Are you reading general international law as part of your LLM curriculum? You are doing? What is the paper name?
International law.
International law, Yogi sir is teaching.
International law. So you must have as part of the sources of law, have you had the occasion to read this case? Case of frontier dispute. So this is an international law subject, international law topic. But let me give you the background to this case. Now these two countries are African countries, both these countries. Now these countries had a dispute as to the delimitation of their boundaries, frontiers. Now they could not resolve this dispute. They signed, a special agreement, which is called, in the court's terminology, a compromis. A special agreement in English language. And by way of this special agreement, agreed that the International Court of Justice delimits the frontier between these two countries and settles the dispute. Now, International Court of Justice, as you are aware, is a body which is composed of 15 judges, and the court is also empowered to fix less than 15 judges on a particular dispute if it believes that there is a special case, and that special case is required to be heard by specialist judges. that is called chambers. Chambers of a court. So chambers mean not the full court but few judges. So in this case, five judges chamber, a chamber of 5 judges was constituted by the court to hear this case. The second procedural observation that you need to know is that a judgment by a chamber of the ICJ is also a judgment of the court. So the sanctity which is given to the judgment of an ICJ is the same that what is given to the sanctity of a chamber. So you can't say that the judgment is by only 6 judges, so it is not an ICJ, it is an ICJ. So that was the procedural context in which this case was submitted to the ICJ. The second issue was the issue of the applicable law. Now, having settled the jurisdiction of the court, it is not difficult for the court to find the law. A tribunal such as International Court of Justice, it is a very qualified court. So you can't expect them then they do not know the law. The problem before the International Court is not of law. The problem before the International Court of Jurisdiction. And jurisdiction was not a problem in this case. Why? Because they have signed an agreement before that. Now, International Court of Justice knew the law. But during the course of arguments, this is what was presented before the court. Now, Republic of Mali urged that the account should be taken of that form of equity which is inseparable from the application of international law, which it saw as equivalent to equity infra legem. Mali was saying that there is inherent equality in the application of international. Law is to be applied in a manner which is equitable. And this equity, Mali said, is equity infra legem. There are different forms of equities. We said equity originated from civil law, but you see different forms of equity. One form of equity is this equity infra legem, which means equity which is applied as law. Equity which in the formulation of the International Court of Justice is encompassed by Article 38, paragraph 1, subparagraph C, that is general principles of law. Second equity. First equity is equity infra legem covered by 38(1)(c). Second equity is equity contra legem. Equity which is contrary to law. In the scheme of ICJ, Article 38, paragraph 1, there is no provision for equity contra legem. That is, I am not aware of any provision under Article 38(1) for equity contra legem. Then court as a judicial body should be empowered to apply in the name of equity something that violates international. There is no provision. Third, equity praetor legem. Praetor means magistrates. Earlier in the Roman, if you translate in the legal system, they were not judges, they were magistrates. So that equity which is devised, formulated by magistrates, in other words, judge-made equity. If you see in the scheme of ICJ, Article 38, it is only available under Article 38(1)(d), which means in the form of judicial decisions. But judicial decisions also have a limitation, that they are binding only in that particular case and between the parties. So even if conceptually that may be included, but you know the statute's limitation on its application. And finally, there is equity in the most general sense, and that is in the Latin expression ex equo et bonum. That is called equity in the most general sense. So you have equity as part of law, equity which is against the law, equity which is made by judges, and equity in the most general sense. This equity is encompassed expressly by Article 38, paragraph 2, which says the court is empowered to give a judgment ex equo et bonum if parties thereto have agreed. Now you should be very careful when you understand. Having known these forms of equities, you have to actually understand which equity these countries were arguing for and against. When they signed this agreement, they did not say that the court settled this dispute ex equo et bonum. So obviously, when you did not say, after signing the agreement, you can't say this. Written form is the final form. Whatever you have said in writing is going to prevail. After that, whatever you want to say orally, that is for public consumption. You can never ignore, never forego what you have said. They never said it that the court should settle dispute ex equo et bonum. In other words, that equity was not available. Now, listen what Burkina Faso said. Burkina Faso emphasized that in the field of territorial boundary delimitation, there is no equivalent to the concept of equitable principles, which are available in the case of delimitation of maritime areas. Students from Bangladesh may hear that in both these cases, which was settled by the arbitration of the United Nations Convention, Tribunal of the Law of the Sea, your arbitration with Burma and your arbitration with India. In both these cases, arbitral tribunal applied equity, equitable principle. Equity in the sense that first drawing a provisional line, considering special circumstances, and on the basis of special circumstances, adjusting that line to produce an equitable result. So Bangladesh argued, for instance, in the case against India, that because of the concavity of its coast, it would produce an inequitable result if the court were to accept the median line as the boundary. The court accepted this. The tribunal accepted this. But that is law of the sea. In the law of the sea, it is written in the convention, agreement, that equitable principles are to be applied. But there is no such a written law about the boundary settlement which talks about equity. Are you getting my point or not?
Yes.
The point is, as far as equity's role is concerned in maritime disputes, that is accepted. The court did not have any difficulty because that is written in the law. So if you apply the law, you have to perforce also apply the equity. So in other words, you are not bringing equity because of your own. You are simply saying it is the one step. You are applying the law. The law is equitable. So ultimately you are going to say that you are applying the law. Equity is embedded in the law. Equity infralegium. Infra means inside. But in the boundary case, there is no written law. I'm not aware of any written law of boundary disputes, of land boundary disputes. And the case before the court was land boundary dispute. It was not a maritime boundary dispute. So Burkina Faso was saying Then fine, we have no problem what Mali is saying, but I am not aware of what equity that you are talking. Because here is a case which is not a maritime boundary case. So how do you do it? What equity you will apply? And if you apply it, what is the basis? From where will you import it? That is basically the thrust of the argument of Burkina Faso. Now, see what did the court say. The court said we will have regard to equity infra. That is that form of equity which constitutes a method of interpretation. And this is the lesson for you from this lecture. That is the critical point. That form of equity which constitutes a method of interpretation of the law in force. So in other words, equity was available even in a boundary dispute other than a maritime boundary, only to the extent that it is admissible as a method of interpretation of the law. In other words, we will use it only as a method of interpretation. So that is a very good development, and that is a very, very significant contribution of International Court of Justice on equity and development of the law of interpretation. Because this is an observation which is quoted from the court's observation. This is very important, and each and every word is very significant. It says that form of equity which constitutes a method of interpretation. So equity infra legem is a method of interpretation of the law. So that is the importance of it. Court is not saying that we will import equity to substitute the law. Insofar as equity is available to interpret it, we are aware we will apply it. But outside of availability as an interpretation, as an independent source of law, we can't apply equity because you have not signed this agreement that you decide by equity. And for that you have to sign clearly. Otherwise the court will be given a judgment against the beneficiaries of the parties, and that will be illegal. Court can't do it. And there you can see the big difference between international adjudication and international interpretation and domestic interpretation. Domestic court, they don't talk this much and they don't care about parties this much. Why? The reason is very simple. The fact that you are the subject, you are a citizen of that particular country, you are already bound by birth that you will respect the judgment of a court. That is not the case with the international court. International courts, countries go to the court only by written agreement. Whether that written agreement is separate, part of a treaty signed today, 20 years before, 50 years before, that is somewhere else. But the critical element is consent, written form. Do you also go to national courts by which you consent that the court will apply this law? This concept is totally alien to domestic law. They don't ask you about the law. They will tell you what the law is, and you have to accept it. Whether you like it or you don't like it. If you shout it, they will send you to jail, you see, under contempt. At the most, you can discuss it with your friends.
Contempt of court.
Yes. So you can see the big difference. The court said, well, I can't apply equity outside of the law because you have never authorized me to do it. I can't do it. Here in this case, you can see it. So, as a method of interpretation, equity infra legem may be applied only as a method of interpretation, but not as a source of. Yes, please.
Sir, I have a question. For example, it is a long time. For example, it's a long time that we have a problem in our border with Pakistan. The Duran line, that it is very well-known line in history of our country and all over the world. So, for example, if if we want to take this dispute, then we should sue it in front of the ICJ. So can we also say and can we sue based on the equity against Pakistan, or we should have some agreements based on equity and then we should apply this equity?
Yes, very good question. You see, the first thing that you need to understand is, if you want to adjudicate this problem by the international court, then you must agree with Pakistan to take this adjudication by international court of justice. Otherwise, you can't get it adjudicated by international court. So Pakistan must agree with Afghanistan, must sign some treaty, or there must be some treaty in existence which you believe then Pakistan had agreed already to get it adjudicated. You see, did you get my point?
Yeah.
There are two possibilities. Either the state of Bangladesh, you see, should say that there exists some treaty where Pakistan has already agreed, and you produce that treaty in your application to the international court, saying that, well, we have this treaty of some 20 years before, 50 years before, 100 years before, and on this basis Pakistan had agreed that if we fail to resolve a dispute concerning our boundary, that dispute is going to be resolved by International Court of Justice. So you adjudicate. Then International Court of Justice will issue a notice to Pakistan saying that we have this application from Bangladesh, from Afghanistan, and you have not settled this dispute with Afghanistan concerning the boundary, and now you reply to this. So Pakistan will have two options. Pakistan may say, well, I don't recognize what treaty you are saying and I never signed it and this does not exist. Or Pakistan will say, well, fine, we accept that you have jurisdiction, but we say that we don't have a dispute and we have given this more territory to Afghanistan and Afghanistan is lying and all these kinds of things. So you have two possibilities. Either you contest jurisdiction, Pakistan will either contest jurisdiction saying that there is no consent, or Pakistan agrees that there was consent, but there is no case of merits in favor of Afghanistan. That is possibility number one. Possibility number two is that you sign a fresh agreement with Pakistan, saying that, well, we have discussed, we have disputed, we have agreed discussed this for so many years. We have not been able to solve it. Why don't we settle it by international court? If Pakistan agrees, then like Burkina Faso is the same thing. They have the same agreement, and you go to the international court. International court will settle it. So these are the two possibilities. Yeah. There is no other possibility. Common point in both the possibilities is this: you have to have a written consent of Pakistan to get it resolved by the international court. To put it from the court side, in the absence of evidence that both the parties have agreed to settle the dispute by way of judicial settlement by the international court, International Court of Justice will never adjudicate. Will say, sorry, I can't do it anymore. Yeah. So this is basically what the court said in this case. Now let us come more specifically in the case of, by way of slight, you see, example I gave you about the Bangladesh case, but people from Bangladesh may now note this case, this is a very important case for them. The first thing that you need to understand is that in this case, it was agreed by the tribunal, specifically at paragraph 68, that this dispute concerned interpretation and application of the convention. So you can see the importance of interpretation in international adjudication. The tribunal clearly said it involved interpretation and application of the law of the sea convention as regards delimitation of territorial sea, exclusive economic zone and continental shelf, along with, of course, land boundary terminus. That was the first thing that you notice. Second, when you came to arguments, you see the arguments of both Bangladesh and India. Bangladesh disputed India's view that the law has shifted from subjective consideration of equity to more objective criteria through the equidistance method. Do you see what India and Bangladesh were saying? Tell us, you people from Bangladesh, you should be able to tell us. I think it is one case in which you must take maximum interest. What was Bangladesh's position on equity? You see, Bangladesh was saying that there is a space for equity outside of the equidistance principle. I will elaborate. India was saying that the concept of equity is subsumed within the equidistance principle. In other words, there is no role for equity outside of equidistance. Again, India was saying that role for equity outside of equidistance principle is subjective. India was saying, in other words, the role of equity within equidistance principle is objective. And the international jurisprudence has shifted from subjective equity, that means equidistance principle plus equity, to equidistance principle. Why? Because equidistance principle itself is equitable concept. So there is no reason to apply any more equity, because equity is embedded in the equidistance principle. This was the bone of contention between the two countries, and both countries marshaled almost everything under the sun. If you see their pleadings, they are more than PhD thesis. You can't read them. The volume is too much. You simply can't read. You will get lost in arguments. 10-15 pages, after that you will not be able to read it. Thousands of pages they are fighting. Volume 1, Volume 2. It is like 2 PhD theses by each country. So difficult, because I know I had to read this case for some purpose, and it was very difficult for me to cull out what these countries were saying. But this was the essence of what they were saying. So this was a position which was absolutely in contrast. Why? Because there were cases in favor of Bangladesh, there were cases in favor of India. Both the countries had corroborated position. It is not that one country is saying sense and one other country is saying nonsense. When this is a situation, then it is very simple for trade. If one country is talking sense and another is talking nonsense, it is very easy for judges. But when both the countries are talking sense, then it is very difficult which one to choose. Because one country had these 5 cases, the other country has also 5 cases, or 6 cases, or maybe 2 cases where one country is saying the meaning of this case is this, the other country is saying meaning of this case is this. In other words, when countries themselves are offering contending interpretations of one single or 2 common cases they rely on. Let us see then another point of contrast between India's and Bangladesh's position. India also challenged Bangladesh's argument that instability and concavity render an equitable line inappropriate. Bangladesh said to India, In other words, if you do not admit of equity outside of equidistance principle, then how will you draw equidistance line equitably when their coasts are concave? That was the main problem. And India had no answer to this. Now let us see what did the court say, the tribunal said. Tribunal stated that it will take into account any compensation Bangladesh claims it is entitled to due to any inequity it suffers in its relation to India as a result of its concave coast. So it accepted Bangladesh position ultimately, saying that concavity of its coast is a relevant circumstance, and that relevant circumstance was good enough for the adjustment by the tribunal of the equidistance line in favor of Bangladesh. So it rejected India's argument that equity is subsumed in the equidistance principle because of the particular nature of the Bangladesh coast. It is, you see, if I should give my opinion, I would say it is very unfortunate for, India to ultimately let this case go to arbitration. As a larger country, as a big country, much bigger country than Bangladesh, it should have somehow, I do not know, of course, when you see pleadings, you see from both the sides. India also has its long story to say that we had been trying to settle this for the last 40 years, 30 years. But I think they should have settled this case without this arbitration. That is not good for, certainly, big brother, a person who is elder or bigger should never let the small person or younger person go against him. You are more graceful when you accept. It's like this. You must have seen two kids fighting over 2 candies or 3 candies. There are 3 candies and there are 2 kids and both are fighting. I will take 2, I will take 2. What do you do? What would the parents advise? Parent would advise to the elder one. Okay, come on, you accept 1 and give 2 to the younger one. Isn't it? It's a very simple, common thing. You can see it happening always. It is a human nature. In other words, if some big person is fighting with a smaller one, so it is always advised to the bigger one. Okay, come on, you just give it. If Bangladesh is saying that you give me some more space, you give it. But I also know the political answer. Answer is political. If Bangladesh is going to give it to anything, the people will shout in Bangladesh. If India is going to say give it to Bangladesh, the people in India will shout there in Bangladesh. Anybody who is ruling party, and they will go against him in the election and he will lose it. So that was basically. So ultimately, that is basically the problem. When you see people from Bangladesh or from Pakistan, India and Pakistan animosity is well known. But believe me, I have had occasions several times to interact with my Pakistan friends, common people from Pakistan. From my profession, I've been teachers, law teachers, several times in India and outside of India. And I have always found them to be very friendly. You know what they say? They said, we have no problem with each other. People of this country has no problem with the people of India. It is the problem of the leaders of both the countries. They have problems. Why? Because it is their professional problem. It is also not their personal problem. They have no problem. Professional problem. For instance, if Mr. Nawaz Sharif is visiting Pakistan in occupied Kashmir, for instance, he is there, and there are 100 people sitting there to listen to him, to tell me, If he can't say that I will support you, they will say, why have you invited this fellow here? I mean, very simple. So to expect Mr. Nawaz Sharif not to say anything about, separatist people in Muzaffarabad is basically a foolish thing. That is yesterday what he said. So some people said, yeah, don't forget about it, don't comment on it. That is his professional, compulsion. He has to remain in Pakistan as Prime Minister. Otherwise, when he will go back to Islamabad, then people from army and people from that, they'll say, why have you gone there? If you don't support them, then why did you go? So this is basically, that's the same thing. So when you see legal problems, you also see it from the political side. The political side is because of the political and leadership democratic compulsion. If Congress government would give anything to Bangladesh, then BJP people will say you have given this, you are anti-national.
Sir, before election, this thing happened, sir. Before BJP India's this year election, this thing happened. Some Indian BJP politician talk about Bangladesh.
Yes, they say it.
For broadcasting.
The whole reason is this. You see, the biggest problem of democratic society is whatever they find handy, they will use it. They also actually have no problem with, just to try and find out how many BJP leaders, or how many people in Afghanistan or for instance Pakistan or Bangladesh leaders, they know Indian leaders. Hardly.
Yes.
At least acquaintance is common in friendship and enmity. So actually personally they don't have any problem. I mean, you just tell me, but Nawaz Sharif may have anything personal against Mr. Modi. You don't know each other. You read both their biographies. Nothing. It is their professional problem. You also come from a party. He also comes from a party. He has to remain Prime Minister. You have to remain a Prime Minister. That's the problem. So if you don't say this, then this is yours. If he doesn't say this is mine, people will. So the problem is he fears people in Pakistan. And what he will not do anything to him. They will do everything to him. There is another psycho. What is made to read by the people, then as if India is going to attack Pakistan. No. Pakistan will attack Nawaz Sharif. Exactly.
That's right.
Of course, they will attack it. Why? Because they are freely available. You can't leave. You can certainly not to go to India and remain safe. But where will you go outside of Pakistan? You have to remain there. So this is basically the problem. So when you see it, my reading of this is, it is basically because they perceive, both these countries perceive that they will not, lose any territory, any boundary. If they do it politically, it is going to be heavy political cost for them in their respective countries, and they just could not do it. That is why they took this position, and I think it was almost certain that they will not settle. 30 years, more than 30, 35, 36 years is a very long period.
Sir, 40 years, 42 years.
Yes.
40 years.
Yes. You just can't settle it. It's a very simple thing to do it. Then there was another case. Let us get back to the United States, and a very famous case this was decided this year in 2014, April 2014. The issue was, this is again, one point that you find is that this is a case concerning interpretation by an administrative agency. So you had domestic law of this country, of a common law type country like India, then you have international law example. You have another example from International Tribunal, from Law of the Sea, Bangladesh India arbitration. And again you have a case from administrative law. Now here in this case was, you see, in the United States what was happening was, multiple states were polluting multiple states. Southern states were getting polluted by the states which were northern states, by air. The problem was, it is possible to count the pollution of the polluted state. But how do you count the contributions of polluting state, because there is no one state polluted, the number of states polluted. That was the whole problem. The question was, how should the Environment Protection Agency allocate, responsibility, contribute, apportion responsibility for a downwind state's excess pollution? How do you say that state A is responsible in 20%, state B is responsible in 30%, state C is responsible in 40%? That was basically the biggest problem.
Sorry that I...
Yes, please.
I think it was last year or 2012 that Australia forest it was burned and there was fire in the Australia forest. So the Indonesian government and the Indonesia, no one was able to see each other in Jakarta because of the smoke. So
yes.
They said the politicians, they were together, they said that for long about 1 month. They said that if there is no obstacle about this matter, so we will see what a case against you in the international courts.
Yes. But you see, in that particular case, the problem was slightly different. In this case, the problem was that, United States is, of course, as the name suggests, is a united entity of several independent states, as they were before the Treaty of Philadelphia Convention. Here you have some state like Texas, like Philadelphia, like New York, these states, and they were getting pollution from states which were northern states. So problem was how to fix the responsibility of more than one polluting state. It is like 20 students of this class are throwing garbage on this street. Some fellow is getting pollution. Now when some person complains against you, then you say, well, I am not doing this, and he is also doing. When he is caught, he says, I am not doing, he is doing. And ultimately, when you all four are caught, then you say, well, I did not do it, I only threw only once, that is this. And you are saying you pay this much. So first you denied, and then you are caught evidence, he took pictures or whatever he knows, and you kept quiet. Then you are saying, then I am not responsible for this much, I only did this much. That is basically the question. So how should the Environment Protection Agency fix the responsibility among these four persons, four states which are throwing garbage, sending pollution to a downwind state? And this is what was the problem before the EPA. And EPA did it equitably. That is why I included this case in this discussion. And this is a quotation quoted from the case at page 27. The court says, Supreme Court of the United States, that eliminating those amounts that can cost effectively be reduced is an efficient and equitable solution to the allocation problem the Good Neighbor provision requires the agency to address. Good Neighbor provision is a law provision, legal provision, which had authorized the Environment Protection Agency to apportion responsibility amongst multiple pollution causing states. Then equitable, he gives an argument, the reasoning given by the court is that by imposing uniform cost thresholds on regulated states, EPA's rules subjects to strict regulation those states that have done relatively less in the past to control their pollution. How did it do so? Now, in the example that I gave you, the equity was applied in this manner. It said, okay, we will find out in last 4 years how much efforts you have done to reduce pollution. How much efforts you have done to reduce pollution? How much efforts you have done to reduce pollution? How much efforts he has done to reduce pollution? Suppose the answer is, in the last 4 years, you have spent $50, he has spent $100, He has spent $150 and he has done $200. So when the cost was imposed, the highest cost was imposed on you, slightly less was imposed on him, slightly less was imposed, and the least cost was imposed on him. Why? Because he had already spent 3 times more than what you have done. This is called equity. So they have given responsibility to all. You all 4 will pay for pollution, but pay in different amounts. Why? Because you have been serious in different degrees. He was most serious. You were least serious. So you had to pay most, he had to pay least, but both will you pay. It's not that one of you will not pay. That is called equity. This is what the court is. And this is in this manner the court had applied the law. So the law is common because you all were 4 found responsible. In other words, substantive equality is there. Why? Because you all were polluting, you all were found responsible. But responsible in different degrees. One is paying $50, another is paying $200. This is called equity. Now let us see 3 broad, conclusions follow. One very simple and a very simplistic and a very noticeable thing is that equity has been an interpretive consideration. We have seen in domestic law, we have seen 2 examples of international law, we have seen an example of 2014 coming from the US Supreme Court. I think it is undeniable that equity has been a consideration in interpretation. That is absolutely clear. Second is, in the context of ICJ, it is noticeable that it has made a distinction between equity, infra legem, and other forms of equity. It said it in Burkina Faso case, we will not apply equity ex equo because you have not authorized. In the case of Bangladesh arbitration, International Tribunal said, well, we will apply equity even outside of equidistance. Why? Because equidistance line will not result in equity because of the particular nature of the Bangladesh coast. If you draw an equidistance line to a concave coast, it will be inequitous to the country whose coast is concave. Because the country whose coast is convex will get more, and concave coast country will get less. It will be inequity. Then third, other considerations in interpretation include usage, harmony, efficiency, and reason. Usage and harmony you find it from Mimamsa principle. Efficiency and reason arguments you also find it from that equity case, that is pollution case, United States case. Well, I have nothing more to say. I have another class at 6 o'clock at Indian Society, so on it altogether a different topic.